All right. Good morning, everybody. Welcome back to our Fireside Chats. Well, welcome back for those of you who have been attending the other sessions. I hope you've been paying attention, following along, visiting the sessions, catching them live so you can ask your own questions, or watching them on our YouTube channel where all the recordings are hosted if you can't make it. Really excited about today's topic. Obviously, it's about employment. We want to build big, wonderful, successful businesses, and that means we are going to have to hire other people to help us. No person is an island. We need support and help from others, and we need to do that effectively and within the bounds of the law. And so that's what we're going to be talking about today. We've got our wonderful legal friends here from Faskins, Elizabeth Reed and John Conlon. I'll leave it up to James Chapea, our moderator, to give a little bit more background on them. But really quickly, I will mention a couple things. We do have a couple events coming up at Foresight. We have the Western Canada European Connect Ag event, which will be running again tomorrow. I believe it's a 3-day event, so do check that out. It is on our events page. And next week, we will have our Climate Connections again in the ag space on the topic there. That'll be next week, June 22nd. Of course, tune in next month for another edition of our Fireside Chats as we explore the topics that you want to know about as you build your entrepreneurial ventures. With that, I'll turn it over to James, our moderator for the day, and he can introduce the speakers and keep everything moving. Before I do move on, I will mention there is a little Q&A function. We would really appreciate if you enter your questions there versus the chat, so that way we can keep track of which questions we answer from our panelists here today. And of course, this will be recorded, so you can check it out later if you do have to leave. James.
Thanks, Stephen. Welcome, everybody. Thank you for joining us for another Fireside Chat. As you know, when anybody that's talked to me, there's 3 things as a CEO you need to do: set the direction for the company, make sure you have the right asses in the right seats, and make sure you don't run out of money. Biggest thing is about making sure you have the right team. And how do you go about that? This is the biggest challenge we're faced today. As we're all seeing, we have the Great Resignation. We have challenges with respect to employees ghosting, which is a rather novel concept. There's all sorts of different challenges, and we want to make sure that you know what you're facing and don't run into the exact same problems. We have with us today Elizabeth and Jonathan, who are experts absolutely in this field. And as Stephen had suggested, please use the Q&A, because that actually can help us not only address your questions, but we can make sure that we're bringing them up to everybody else, or just helping you directly if that's how you prefer to deal with that. So we will make sure that that's being monitored. And I would like to now turn it over to Elizabeth and John. They can give you a little bit more of their backgrounds as to why it's relevant and get in deep into this presentation. Please do not hesitate to ask your questions. This is for you to make sure that you know that it's just not cause yourself more problems than you need, and make sure you actually, more importantly, know that there are questions that you should be prepared to ask. So what are those questions? So let's turn it over to Elizabeth.
All right, thank you very much, James and Stephen. I'm really excited to be here with you guys today. So my name is Elizabeth Reed. I'm an employment, labor, and human rights partner here at Baskin. And I have with me my colleague, John Conlon. John specializes in corporate venture capital, private equity, and M&A law. John, is there anything else you want to add about your background there before we jump in?
Thanks, Elizabeth. No, I think that's great. All I'll add is that as part of the panel, what you'll see is that Elizabeth is certainly the expert, but in my practice, I am constantly dealing with employment issues when companies are selling or raising money, or in other kind of major transactions. So that's the expertise that I'll bring to the session.
I also asked John for any advice as soon as you tell me stocks or stock options. I'm like, I'm just going to call John now. So that's one of the advantages of our team is I love having those resources because we have all these areas that kind of overlap. So without further ado, our agenda for today is our first We've got about kind of 30 to 35 minutes of kind of prepared material for you, following which we'll have some time for some general discussion. If you have any questions as we go along, please don't hesitate to ask. You won't throw us off. We're happy to kind of take them as they come. I might just ask James or Stephen maybe to let us know if there is a question in the chat box so that we can answer it. That would be great. And then a couple of caveats, just because we are lawyers, so there must be some fine print. We're providing kind of general legal information today, and we understand that there are kind of people across the country, so it's going to be necessarily at a fairly high level. We can't give specific legal advice on really specific situations. So if you have a specific question that you're kind of looking to ask that is going to impact your business right away, and it's not kind of at that general level, then we may not be able to do that in this forum, but we could perhaps talk to you after, or you can get in touch with us at a later time. The other caveat is that John and I are both called to the bar in British Columbia. The law can differ across the country, so just sort of keep that in mind. As again, we'll try to keep things at a level that they will be applicable for everyone, but there can be some nuances in different jurisdictions. So just keep that in mind when you're kind of looking on the internet at things as well. You may be reading about employment laws, and just kind of be aware that those can differ from province to province. So we've got a little bit of a case study. So essentially, what I've done is I've kind of created a fictionalized account of George and Sandeep and their brand new company, which we've called Clean Tech. Not maybe the most creative, but we'll go with it for now. And this is kind of their sort of little story is made up of all kinds of the things that John and I see every day in our practice, and unfortunately sometimes kind of see in the case law, or in my case, I may be in court trying to defend some decisions that were made at the beginning of an employment relationship. So this is kind of a morph together of all of those things, and I'm sort of hoping that by doing it in that way, it's maybe a little more interesting. And then, so what I'll do is I'll give you the kind of background of the story, and then we'll dive into some of the legal concepts we need to understand to kind of analyze that. And then we'll look at basically, what could George and Sandeep have done differently, and how could they have kind of, maximized their legal spend to kind of get the most bang for their buck, and what will kind of keep them out of trouble, or what are they going to be looking for next time, so that you guys can learn and not make the same mistakes that they might make. All right, so Sandeep and George, they meet in graduate school at UVic's School of Earth and Ocean Science. They come up with this great idea for taking heavy metals out of fast-running streams. And they do a couple of corporate gigs for a while, but they really are entrepreneurs at heart. And so they decide to build out a team and have their own business. They quickly realize that they cannot do it all on their own. As I think both Stephen and James alluded to, it does take that village. So I'm going to tell you a little bit about their very first hire. So the first person they hired is Kimiko. Kimiko was a brilliant scientist that George met at a conference. Now, when Sandeep and George were talking about hiring Kimiko, they realized pretty quickly they probably couldn't pay her a market rate salary. And they also wanted to make sure that her interests were really aligned with the company. So they decided that they would offer her an ownership interest in the company, as well as entering into an employment relationship with her. So after a few discussions, George calls up Kimiko and says, "Hey, what do you think? Why don't you come work for us?" They have a couple of chats back and forth, and ultimately George sends Kimiko an email confirming her title, how much they're going to pay her, and he also tells her, Sandeep and I want to offer you 1% of the company. Kimiko texts back a few hours later, "Sounds great, let's do it." And a few weeks later, she walks in the door and she's now working for Clean Tech. Now, 3 or 4 weeks after she gets started, George kind of realizes, well, we don't actually have anything in place. We should probably document this in some way. He's kind of alive to that issue. So he goes to the internet and he finds a contract. And in this particular story, he miraculously actually does find a contract that is the right jurisdiction, has the right clauses, and has a proper severance clause in the case that he might ultimately have to terminate Kimiko's employment. So he finds the unicorn, basically, fills in his details, gives it to Kimiko, she signs it right away, and off they go on their merry way. Now, a few years later, a pandemic hits. Kimiko says, hey guys, I'm the VP of R&D now, and I really think I can do my job. I don't have to be in the lab. I can do my job from my family's cottage in Ontario. So they're originally based in BC. She says, I want to go work from the company cottage. So off she goes to Ontario, and she's doing her work. Things are still going well. But then about 4 years later, there's kind of a change in the focus of the business. They're kind of getting out of the R&D phase of things. Maybe they're selling that piece off. At any event, they're closing down Clean Tech's R&D department. And, they make this difficult decision that they're going to do that. And of course, they have to end Kimiko's employment. So they go back to their signed employment agreement, and they go, okay, well, this is based on the BC Employment Standards Act. We're going to give Kimiko the 7 weeks under her contract because she hasn't done anything wrong, not her fault. And they give her the 7 weeks, and they think they're all good. Now, to their surprise, they get a letter from a lawyer for Kimiko a few weeks later, and that lawyer is demanding not the 7 weeks, but in fact 12 months notice or pay in lieu, and she's also looking for a considerable sum to compensate her for the loss of her ownership interest in the company. So it's a bit of a story, but it's not uncommon. This is exactly the kind of story that we see happen all the time. So let's have a little look at what is the legal background that we need to kind of figure out, what we're going to do with Kimiko's case and whether Kimiko even has a case. All right, so it kind of covers a bunch of different legal topics. First, kind of how do you form an employment contract in the first place? How does that happen? Some implied contractual terms that you'll may be surprised to hear about. Termination of the employment contract, of course, and how do you actually sort of do that? What do you have to provide people when that termination happens? Brings up some remote work and jurisdictional issues, and some changes to terms and what we talk about in employment law is fresh consideration for changes to the contract. And then, of course, it also brings up this equity piece as well, which I'll get John to jump into when we get to that piece. So people are often surprised at how very easy it is to enter into an employment relationship. Generally when we think about an employment contract, you think about something formal. People have in mind this like 12-page beast that has all kinds of heretofores and wheretofores and party of the first part and all of that kind of stuff. But it is in fact very easy to enter into an employment relationship and actually have a binding contract. So essentially, as soon as you know who the parties are, what the price is, i.e. the salary or compensation, what are the kind of general services to be provided, i.e. I'm going to come work for you, and both parties have agreed, and they're both getting some kind of benefit out of the arrangement, you have an employment contract. So literally, if I say, hey, John, can you come, sweep the floor for me for $10 an hour? And John comes and says, okay, sure. And I make it clear it's an employment relationship. We have an employment contract that is binding and enforceable, whether we were thinking of it in that way or not. So the other kind of trick with this is that the law likes to kind of make arrangements for people. So there's sort of a whole kind of body of law called the common law, which is essentially law made by judges as they kind of develop and decide cases. And through that common law, there are principles of what we call implied terms. So these are terms that whether you wanted them or not, whether you even thought about them or not, they are in your employment contract as soon as you have one. That's why we call them implied terms. They're implied by law. You didn't write them down anywhere. They're just there. And there are a whole bunch of them. But the biggest one that I'll kind of focus on today, and for the purposes of our little story, is about termination. So in every employment contract, there is an implied term that the employer won't end the employment relationship except by unless they have just cause, to do so, in which case they can provide no notice, or if they are going to end the relationship without cause, they must provide what we call reasonable notice. So you've got sort of those two sort of pieces. One, essentially the obligation is unless you have just cause, you won't terminate except with reasonable notice. So, what is this reasonable notice? Well, essentially, it's a period in which the employee can spend some time looking for another job. So the sort of explicit legal obligation is actually to give the notice in advance. So I might say, okay, you know what, I'm really sorry, James, we're going to have to close down the department, and in 3 months, your employment is going to end. So it's like an advance notice period. Now, and that's why we call it notice. Now, realistically, in the real world, we're usually talking about a payment instead of giving that notice. So basically, we pay out the equivalent of what that person would have earned during the notice period. And we do that for obvious reasons. If I tell James, sorry, you're gone in 3 months, he's probably not going to be super motivated. He might be running off, going into my confidential information, and he's got time to take it before he leaves. So for all kinds of different reasons, we don't usually actually give that notice in advance. Usually you'll say, okay, your employment's over today, but we're going to give you this notice, this payment in lieu of that notice period that we were going to provide. And that sort of colloquially gets referred to as a severance package or severance. There's a whole bunch of detail about what strictly speaking is severance package or not, but for the purposes of today, we can just call it a severance package. So how do you decide how much notice you have to give? What's the law on that? Well, there's basically 3 places you're going to look for the notice. First of all, you're going to look at a contract if you have something in writing. That's the first place to look. The second place is you do have to provide whatever notice is required under the employment standards legislation of the province that the employee is employed in. So every single province has their own employment standards legislation, and that provides for a specific amount of notice. That one's really easy to figure out because it's based entirely on how long the person's been employed with you. So your most senior executive gets the same amount as the person who just started with you yesterday. Well, it's the same amount as if they'd all been there for the same amount of time. Anybody in a kind of a lower level position would get the exact same as the more senior people. So it's only based on length of service. And that ranges from about, somewhere between 1 to 2 weeks at the kind of early stages of employment, and it can vary across the country, to a maximum of usually 8 weeks, if they've been with you for 8 years or more. So fairly modest entitlement. And the other big thing about employment standards notice is that it is guaranteed. So even if the whole purpose of a notice period is to give you time to find another job, even if I find a job tomorrow after I get terminated, I still get that full 8 weeks if I've been there for 8 years or more. So it doesn't matter that I found another job, the employer still has to pay me that 8 weeks. So the last piece of place to kind of be aware of in terms of notice is notice under the common law. And I left this one to last because it's the biggie. The notice under the common law is where you default to if you didn't put anything in your contract. So your contract is either silent or you don't have anything in writing. So then the employee will have this right to notice under the common law. And we're usually worried about that. That's usually what people are talking about when they talk about notice, because it's quite a lot longer than the Employment Standards Act notice. And so, for example, if my common law notice is 2 months and I'm only entitled to even say like 1 week under the Employment Standards Act, your common law notice is not on top of that. It includes your employment standards notice as well. So that's why we usually default to looking more at the common law notice. So the notice under the common law gets determined by looking at previous case law. So it's a lot more complicated. The courts have said, we're going to look at all the factors, and that gives them a lot of wiggle room. So if you give me the exact same fact scenario, you tell me, okay, it's a 40-year-old employee who's been with the company for 18 years, and they were a senior VP, and it's, they should be able to find another job, but it won't be easy. I can probably find you a bunch of cases that will give that employee, X amount of notice, and my opposing counsel on the other side, they'll be able to find a bunch of cases that will give that employee, 3, 4, 5 months longer than the cases that I find. So basically, it gives the lawyers a lot of things to fight about, which can get very expensive. So that's why, we do want to try to avoid having to get into that common law notice fight if we can. The other big difference between kind of the statutory notice and the common law notice is your common law notice is based on, is subject to what we call mitigation. So it's really intended to give employees a bit of a cushion. So under the common law, if I'm entitled to 10 months notice, but I go out and I find, an employment, another employment at a similar level of pay, within a couple of months, then basically the court's going to say, okay, well, yeah, the employer should have given her 10 months, but she was able to kind of reduce those losses by finding the new job, and therefore we're only going to give her 2 months. So that's kind of something to keep in mind, because when we're looking at severance packages, if we don't have a contractual kind of obligation, then we're kind of crystal ball gazing. Okay, how long do we think it's going to take for this employee to find another job? And the opposing side will say, oh, it's going to take them forever. They will never find another job during the notice period. And we'll say, what are you talking about? They're a fabulous employee. They'll get another job tomorrow. And then we kind of try to come to something that everyone can live with. So that's sort of how it plays out, kind of practically speaking. So that's sort of the really high level, quick overview of notice entitlements. We'll talk about it a little bit more when we look at our specific case scenario. The other thing that this kind of scenario brings up is remote work and jurisdictional issues. So as we discussed, in every province, there is separate employment standards law. And the reason that this becomes an issue is because if you have a contract that complies with British Columbia law, it may not comply with the law in, say, Ontario. In fact, it definitely will not. If it's just BC specific to BC employment standards, Ontario has a higher standard, so you're not going to be complying with Ontario standards if you're using a BC contract. And the reason that becomes kind of ties into our common law issue is that if you actually have a written contract, but that contract, is for some reason inconsistent with the applicable employment standards law, the courts have no compunction about tossing out that clause and saying, well, fine, we'll leave the rest of the contract, but we're not going to enforce your termination clause because it doesn't suit. And you're back in this area of common law notice again that you were trying to avoid in the first place with your contract. So that's where it comes up. The other thing to kind of think about in terms of remote work, we don't get into it too much in our little story here, but different jurisdictions, it's not just the termination clauses. It's when overtime kicks in. It's what records you have to keep. It's when you have to pay the employees. All of these kinds of things are dealt with in employment standards legislation, and there are subtle differences from province to province. So that's why, when an employment lawyer hears, oh yeah, we just let them work, go work somewhere else, we kind of go, oh gosh, okay, all right, everybody breathe, we'll sort it out. But it's not, people sort of think of it as like, well, the company's here in BC or the company's here in Nova Scotia. Why does it matter where the employees go? But it actually does, because that's where the law of employment kind of starts to apply. A place really where the law has not caught up, certainly with the pandemic. And it will be very interesting to see how the law develops over the next few years in that area. The other thing that this little story kind of brings up is changes to terms and conditions of employment. So whenever you're adding new terms, you have to be a bit careful if they are, substantial terms. Because generally speaking, the employer has the right to kind of direct the workforces, and there's some flexibility there. But if you're changing major things like compensation, like severance packages, those kinds of things, and you want the employee to sign a new contract, you're generally going to have what we call consideration for that change. So you're going to get something out of it, but the employee's got to get something out of it as well for that new contract to be enforceable. So that's something to always keep in mind. Okay, what is the employee getting out of whatever this big change is that I want to make? So any questions about that kind of overview before we jump into, does Kimiko have a case, and kind of what does that look like?
Where do I start? Holy cow. That was a great that was a great start. And I won't even get into the fact that I probably by this point would have been called in for sensitivity training on something I would have done at this point. But let's just try. First off, you actually raised something that was kind of interesting. So we found Kimiko. We said, we talked to her and we said, come and work for us. And now she's come and start, and don't worry about the paper, we'll get it to you.
Yeah.
Okay, so we'll get you the employment contract. Do we have a problem at that point? That's one of my questions, because where do we go with some of that? Is does that contract enforceable, or how do we deal with that? And then we'll get into something else I was kind of curious about on that.
Okay, absolutely. So that takes us brilliantly. James, you could not have done that better for me. Does Kimiko have a case? So yes, she definitely does. And we can go through why. To answer James's question about, is there a problem here? Yeah, there sure is. And the reason is that George and Kimiko, their email and their text actually created a binding employment agreement and contract that was terminable, had this implied term that it would only be terminated upon reasonable notice to Kimiko, and that's going to be that reasonable notice under employment standards and and more importantly under the common law. So, George was kind of alive to the fact that there should be some kind of documentation here, so he did bring in this new contract. But the problem was that was actually a new contract. George was thinking of that as the first contract, but it actually wasn't. The first contract was created by just this email and the text. And then, so when George came in, he's bringing in a contract that doesn't have any new benefits to Kimiko. So in this story, he didn't give her a signing bonus. He didn't add anything, to what they had talked about. It was just kind of what they talked about. But he included, of course, in the contract, as most, any employment lawyer will recommend, terms that would limit her ability to claim common law notice. And there's nothing wrong with doing that. Parties are allowed, you can't contract out of the employment standards notice, but you can agree, as long as it meets the employment standard minimum, you can agree to anything else you want for common law notice. So you can say it's going to be just overlap with employment standards and that's going to be it. Or you can have, for a very senior CEO kind of level person who's been with the company for a long time, generally speaking, there you'll see very generous severance clauses, or what we sort of joke about is like the golden parachutes, they're the ones you hear about in the news. Somebody got terminated and they got millions of dollars in their severance package. So you have that flexibility. But here they got into a problem that new contract, the written contract that George wanted to put in place wasn't actually enforceable because there was no fresh consideration, no benefit to Kimiko for that change. So where does that take us? We end up back with entitlement to notice under the common law. So they're looking then at Kimiko's age, her years of service, her position, availability of similar employment. They put it all in the hopper, and probably for someone at that point, I think we said she had 8 years of service or 7 years of service. Let's assume she's kind of mid 40s. She's in a senior role. They could be looking at, a minimum 7 months, I would say these days, and some courts could go higher. And there is a risk of that. She gets a bad draw, Sandeep and George get a bad draw. They love, the judge loves Kimiko and feels like it's going to be impossible for her to find, a new job. They could be even looking at as much as 10 to 12 months. So a huge range, basically, for people to kind of argue over. And I think the point I'd kind of make there is, if you're doing this at the beginning, everybody's happy, they're getting along, they're like, okay, yeah, this seems fair. you get to the end, they're upset, they're disappointed, they're kind of at loggerheads. It's a lot harder to come to an agreement on what would be a fair package at that point.
Okay, so we're getting some questions in, so I want to get to try and help them out. But there was something else that is when you set this thing up that I wanted to touch on, because when you said they're going to get 1% of the company, what you didn't say, and John might be able to help here, it didn't appear like there was any vesting that took place. It's just like they got it. And so, now this was a longer period type of relationship, but if it really didn't work out, and we're a year into this, and we do have employment, whole bit, they now have a percentage of the company. They could be a very disgruntled employee. They could be all sorts of different things. You have shares out there now. You have a shareholder that's now not just an employee, but a shareholder that's now disgruntled. That's something I was wanting for you to touch on. And somebody said, well, instead of just hiring these people, could you just make them contractors at an early stage and try and avoid this, or are you going down a slippery slope where they could actually say, well, they're not actually contractors, they become employees anyways? And then last thing, I really am curious about, because it is this remote thing that you set up, we now got employees working all over the place. This person quit, and maybe they were there for 4 years. Did we do the proper withholdings? Could we actually have all sorts of tax issues? Or do they get solved because when we're making our payroll, we would actually just have them in a different jurisdiction, but they changed and maybe we didn't do it. So kind of lumped a bunch of questions, and then we got Q&A to deal with as well. So how's that for bombarding fire hose?
No, that's great. That's great. These are all exactly the kinds of things we deal with. So fortunately, I know the answers.
Oh, good.
Now I'm going to defer to, shall we start with the kind of equity piece first, and then kind of jump into the employment part. So I'm going to turn it over to John on that piece, because that's kind of more his area of expertise. So what are the issues that you see, John, with this 1% of the company concept that they've entered into?
Yeah, so I think the concept is something that opens up a conversation, or let's even go one step earlier than James's question, which is 1%. What do the parties think that means, right? And so what we see in practice is one of two things. Either that means that the intention is to issue shares equal to 1% of the company at the time the promise was made, or even complicating matters further, the right to be issued shares equal to 1% on a floating basis. Oftentimes employees will mostly unfairly expect that they have some sort of undilutable 1%. If you are being issued shares and becoming a shareholder, putting aside all of the corporate technicalities that you would be required to adhere to do that properly, director's resolution, consideration being paid, etc., those shares are being issued on the expectation that the employee is going to fulfill their obligations over a negotiated period of time in the future. Oftentimes you see a period of 2, 3, 4 years. Now the shares are issued, so how does vesting work? Well, oftentimes companies will install a mechanism that allows them to claw back shares, what's known as a reverse vesting period, such that if the employee leaves, the company has the right to repurchase the shares at the original issue price, which was usually nominal in that case. And then, of course, if they're a shareholder, what shareholders agreement is in place to ensure that things are dealt with in the ordinary course, and also in the event that the company undertakes an important transaction. You, of course, would not want your 1% shareholder holding up a sale of the company or a financing, for example, right? That's the share side of things. But often the intention is actually to issue options. under an equity incentive plan? Has the company established an equity incentive plan? If you're talking about the grant of options, then you're taking a more traditional approach to vesting, in that you have an option to buy shares, and as you work for the company, that option unlocks, it vests over time. And making sure, and obviously it wasn't done in our fact pattern, that that option is subject to customary terms that protect the company, again, in situations like if the person leaves, for example, if they leave halfway through their vesting period, what rights apply to the vested portion of their option? Can they exercise it for 30, 40, 50 days? In this fact pattern, it's likely that if there was a departure very early on, none of the options would be vested, right? But, you know, issue spotting all of this and getting it into the paperwork at the outset is going to save all of you as entrepreneurs a lot of headache in the future.
Okay. Thanks, John. Elizabeth.
Okay, so yeah, thanks, John. That's this is why I go to John with these questions, because it's way outside my expertise. But moving back onto the employment side, which is kind of my realm, you asked whether, you know, we could avoid all of these employment problems by having these people just be consultants instead. And the answer is possibly, but you've got to be really careful about how you set the employment relationship up. Or sorry, set up the working, let's call it a working relationship. So in the context of these working relationships, you basically got a continuum. So on one side, you've got employees who are heavily regulated. You know, there's specific legislation. There's not really the same freedom of contract. They're really working in your business. They don't have their own business. And the other key thing about employees is you can be liable for the things that they do if they screw up while they're working in your business. Now, on the extreme other end, you have the independent contractors. So those are really people who have entirely their own business. They would have their own customers. They are often incorporated. You know, they are not dependent on the hiring business for their income or for their revenues. So, you know, think about like two super independent agreement, you know, businesses like, you know, a law firm maybe hires an accounting firm to do something. They clearly have their own things going on. They're just working together on one specific project or for a specific period of time. Whereas and then the other difference is, you know, employees, usually you think about that as a longer term relationship. The place where I'll kind of caution you about assuming that we can just use people who are independent contractors is, especially when you have someone who's just an individual or even a couple of individuals working for the business, there's a real risk that they are ultimately going to be either found to be employees, because you can have actually what we call an incorporated employee. So they basically look like, you know, a contractor for a few things, but they're actually at law an employee. And then the other sort of dangerous area is you have there's actually like a middle ground, and that's the one that people really are surprised by and often don't know about. And these people are what we call dependent contractors. So they are people who, they might still have their own business. They probably, you know, pay their own taxes, like their own income tax, their Canada pension plan, their employment insurance, but they've really become integrated into the business that hired them. So, you know, they've been working for them for a long time. They're often not doing things that are kind of project specific. They're just kind of generally helping out. They, you know, often will have like business cards from the company. They kind of start to become the face of the company. You know, they get invited to the Christmas parties. You know, they're basically working extremely closely with the company over a long period of time. And eventually they often don't have any other customers. So they become financially dependent on the company, and the company's fine with that because it works for them. But in that case, if you end up with one of these dependent contractors, so they haven't quite kicked over into employees, but they are going to still have rights to notice and to payment on termination, which is often a big surprise for people. So, I mean, fortunately, all of these things can be mitigated. So you can actually have contracts that will make it clear that if you are a dependent contractor, you will, you'll get a specific kind of notice, and then you should be fine. You can avoid that common law notice, but it's all about being really intentional at the beginning. What kind of relationship do we want to try to establish? And then let's maintain that relationship in a really consistent way. And that's where it gets challenging, because what we often see is somebody will start as a consultant. And actually I had a whole separate fact pattern that I realized I had way too much content for you, that involved someone who worked with the company for a long time. And originally they started with, they had a whole bunch of other customers, but it went really well and they were really enjoying working together. And then you can see how it happens, right? And then all of a sudden in 6 months, 12 months, a year, all this person is doing is working for this company, and they're starting to look a whole lot more like either a dependent contractor or an employee. And you're busy doing other things with the business, you're trying to get investors, you're doing your marketing, you're not thinking about, oh, hey, you know what, I've been working with Stephen, and all of a sudden Stephen's not doing 5 hours a week for me, Stephen's doing 40 hours a week, and we stopped bothering having him invoice because we know how much he's going to get paid anyway, it's going to be the same, and oh, hey, it'd be so much more convenient if Stephen just had an email address like at my office, so we'll do that. And then next thing you know, Stephen's either, best case scenario, a dependent contractor, and you're not offside for tax, workers' compensation, and a whole bunch of other things. And worst case scenario, Stephen has actually become at law an employee, even though he has some of these other attributes of a contractor. So key thing is be intentional about the relationship and then maintain it in that way and keep an eye on it to see how it's changing in the course of time.
Okay. So, one of the things that we get into is a lot of this remote work thing where we're now someplace else, because there's so much of that going on. How do companies actually look at that, and where can they find themselves in all period of hurt as far as taxes or so forth? What questions do they need to ask? And then, is there a real difference besides saying, well, I'm only doing that because of family reasons for a month versus, I'm just now, the month turned into 6 months, turned into, I'm just there. Elizabeth, how do you look at that?
Yeah, no, happy to talk about that. So basically, within Canada, I'll talk about within Canada first. Anytime you have the employee working out of a different province for any sort of, indeterminate substantial amount of time, you should be starting to think about, is this going to be changing what law is regulating our employment relationship? And I wish I could tell you like, it's okay, after they've been gone for 2 months, that's when it is, or after they've been gone for 6 months, that's when it changes. But we haven't seen enough of the cases come through, since the pandemic has started to kind of really have a good sense of when the courts and the tribunals are going to say that shift has taken place. It's pretty clear that if it's for a defined period of time and it's short and you're just doing a little project and then you're always, the intention is to come back, that we deal with, pre-pandemic, not really that big a deal, not really going to change the jurisdiction of employment law that applies. It's really when you have this kind of more undefined, I'm going to work there indefinitely, and then they end up being there. I would say as a guideline, if they're going to be working from somewhere else for more than 3 months, I'd start looking at it and start thinking about it. If they've already been gone for a year, I would definitely be worried about it. And just, well, not worried is the wrong word, but realize that it's something that we need to think about.
Right. Now, but it happened because of the pandemic. There's an interesting twist to this. So now you said they have to come back. They're saying you have allowed me to work there, and you calling me back, would that represent constructive dismissal and change of place of employment? And this whole idea of what can you change versus what can't you change, creating a dismissal event.
Yeah, no, that's a great point, James, because that is an issue. And I think, in the early days of the pandemic, everybody thought this was just going to be for a couple months. So, nobody worried about it too much. But if you weren't intentional about that when the person left and said like, hey, we're going to let you do this, but we are reserving the right to call you back. You may have a problem if you let them be gone, and you never addressed it and talked about the fact that, your employment is really based out of this province or this, office. And we do want, the right to ask you to come back on notice. Now, there's ways you can do that. I mean, worst case scenario, you might have to tell them, look, we want you to come back. If they absolutely refuse and it's gone long enough that probably a court would say, well, no, the company agreed they could work from there indefinitely, and there was no requirement for them to come back. If you want them to come back, you're going to have to terminate their employment and say, look, all right, well, we're giving you 6 months notice that, this contract is ending. We're happy to offer you a new contract in Vancouver starting at that end of that 6-month period. But if you don't take it, you're gone. And essentially, like terminate the relationship. And sometimes people have had to do that. So it can be very factually dependent, though. Can depend a little bit on the industry, what's kind of common practice. That's the challenge. So it's sort of like, as an employer, just always realizing, you have the right to do certain things, but you want to make sure you reserve those rights if there's a big change. And I would say, like anything like a move to a totally different location is a significant enough change that you need to be thinking about that and dealing with that, at the time it happens.
And that's just dealing in Canada. And I wouldn't even want to hazard to guess what happens if you said, well, I really want to work in Hawaii because it's like a little bit better climate. And that's.
I'm moving to Bora Bora. Sorry, Faskin.
Yeah, where we took remote working to a whole new level.
Yeah.
John, I was wondering on something that I have seen that is really bad is when we're setting these things up and we're bringing people on in early days. Was curious about these what you've seen that is really the biggest mess ups that cause problems that then are hard to actually get rid of. So you just want to make sure that you're not doing it day one, as far as ownership, or the options plans and so forth. What are the where are you seeing that, and how do we actually make sure it doesn't happen? So they should talk to you before they do something.
Well, I would say there's probably at least 2 major buckets of biggest mess ups that I see. One is not ensuring that the people that you're paying, and I'm just going to use the kind of non-legal umbrella, are assigning ownership of what they're making for you to you. That can be just absolutely critical, and in some cases fatal to financing and M&A transactions. So the obvious example is employees and consultants not assigning intellectual property rights to the company.
That's one that, so you could actually find yourself in a whole world of hurt if the company doesn't even own the IP that's getting developed. Or is there common law that would protect me? Or
in some cases, yes, and Elizabeth knows that as well, but there's many cases where, and part of this is driven by your potential investors or your potential acquirer, what their expectations are, and saying, we are not willing to simply rely on the presumptive ownership that may exist under the common law. We need positive assignments of a variety of things in a contract in favor of the company to get comfortable here. And that's okay. Reasonable expectation. And then the second piece is, I would say, as a takeaway for the audience, allowing a situation where a very small minority owner of your company has an outsized amount of control over a corporate event. So if you, in our example, the 1%er, if you are not careful with how your documentation is created, you may find yourself in a situation where that person's signature is required to complete a financing. That person's signature is required to sell your company. And you can imagine how unfortunate it would be if at the 11th hour, after you've taken great pains to negotiate a great financing or sale or merger or whatever have you, you have to go to this person who may have left under not great circumstances, and that person now knows they have leverage in the negotiation, and the company is not in a great position as a result. Those are probably the two of the key areas where, when mistakes are made, they have a really big impact.
I've actually seen that last one, and it's absolutely a company killer. And I've seen where companies have actually had to get blown up just because they could not deal with it. You ended up, without realizing it, giving somebody a veto, and that just is not tenable, and it's non-financeable. So thanks for that. We're going to get into what a quick question. We did have a question of how advisors fit into this thing. Where do they fit in the continuum? They're not employees, or how do you see those, Elizabeth?
I know. Are you thinking like somebody who's like on an advisory board or something?
Yeah, like an advisory board. Not saying they're not board members, because those are employees, but advisory board where they advise the CEO, but they're not employees.
Yeah, that's an interesting one. I mean, and I'm assuming they're kind of people who sort of come in, maybe once a month or something, and sort of give some advice.
Right.
Now, are they being compensated for that, or are they just kind of volunteering their expertise, or getting like a little honorarium of some sort?
Well, that's the thing. There's can be all over the map. They could be getting paid. Usually the advisory board is a step prior to forming the real board. So, they're advising the CEO, but it could be options. It could be, which I know there's another point where you probably shouldn't do that. But, how would you expect to treat them?
Well, they're either, if they're not getting paid and they're sort of doing it out of the goodness of their heart to help this startup, they're probably just volunteers, and there's no kind of expectation. There's no actual kind of business relationship created in the sense of like obligations either way. There could be, depending on what they've undertaken to do, there's all kinds of things that could happen. They may be consultants. So when we talk about consultants, usually they're independent contractors if they're getting paid for some of the work. I wouldn't be too worried about it if they're just doing like occasional stuff here and there. But the more and more involved they get in the company, the more you want to start looking at, okay, let's tie this relationship down, and figure out exactly what we want to be to each other.
Okay. In the last few minutes of what we got, want to make sure we get covered. If there's anybody that has other questions, please do not hesitate to put them in there. If there are, and if either of you want to answer some of the questions that are there, that I've taken care of one of them. There was a question about poison pills versus golden parachutes, and one really is about the company, not about the individual. But here's the thing with a lot of these early stage companies, you're going to have to be very flexible as an employee because the company has to be flexible. So do you see these situations where there's a change in, like, the company can't pay as much or has to deal with, making adjustments on these parts of the compensation just to make sure that the company does survive? Do these become challenges with respect to constructive dismissal, or like could you actually have employees holding you to being able to not allow the company to be able to function?
Yes, you can certainly risk constructive dismissal. So the key thing is kind of how does it get communicated and how does it get documented if there's going to be a change like that. And essentially, and this came up a ton in the pandemic, because of course everybody was like, what do we do? And we can't, if, like, we don't want to lose our employees, but we can't pay them for a certain period, or we're going to have to shut down the business for a few months. And the key thing is how it kind of gets characterized, because if there's sort of a concept of forbearance of termination.
Okay.
So if you literally are in the place where you have to do this, or your only other option is to terminate the employees, and you've essentially told them that, like you've said, like, we're going to have to do this, and we are doing it unless, but if you're okay with agreeing to that, to a lower salary for a specific period, sometimes you can work that out with them, and then basically the benefit or the consideration to them is they don't lose the job entirely. But you can't just do that unilaterally. People think like they can just change it unilaterally and it's no problem, but no, you have to actually kind of be in a specific position before you can do that. From a legal perspective. Otherwise, I say, if you're changing salaries or overall compensation, you have a little bit of flexibility as an employer. A 5% decrease is going to annoy your employees and they will be grumpy, but you haven't constructively dismissed them. When it starts to get to more like 15%, then you're starting to get into that constructive dismissal potential territory, where you're changing a fundamental term and condition of their employment. Because of course, what they get paid is one of the most important pieces of that employment contract. Certainly if you're making like a change of like 50%, well, you better document that properly and you better get their agreement that they're okay with that. So one of the things we did in the pandemic was we basically said, look, if you want to we'll keep your job for you. And we had it all in writing, and it would say like, we'll keep it for this amount of time. And, and we made it really clear that otherwise the option is we have to terminate you now. And then you would have to do it with notice, because it's not the employee's fault that the company,
Right.
Well, I mean, it kind of might be, but generally the courts will not see it as the employee's fault that the company's not doing well. So, and that's, the only key thing I'd say on that is that's why it's so critical to have a proper employment contract in place that lets you terminate, and lets you terminate on not a whole ton of notice, because that's how you get that flexibility.
Thank you for that. So I think we're at time. I just want to thank both of you very much for your words of wisdom. So important. This is absolutely the most critical thing that companies have to do to get right. They need the right people in the right places. So I want to thank you for that. For our audience, thank you for participating. Hope you got something out of this, and we can actually, now have people to know that maybe there are some questions that should be asked and not just going according to what I feel like doing at a given time. So with that, I'm going to turn it over to Stephen. Thank you all. And Stephen.
Thank you very much, James. Thank you, Elizabeth. Thank you, John. I think I would sum it up. It sounds like a stitch in time saves 9. If you do your preparation now, you will save yourself headaches down the road. There are fantastic folks like those on the call here at Faskins. I think they participate sometimes in our office hours. They certainly are open to some quick phone calls with Foresight Ventures to answer any questions. Obviously, if it gets into writing those contracts, as Elizabeth said, those employment contracts are so important. Probably need to get a little bit more engaged with them. But thank you for taking some time today to outline some of those problems. Stay tuned. Next month, we will have another Fireside Chat, and the topic will be coming up shortly. So check your email inboxes. We look forward to keeping you apprised of all the different things that you need to be thinking about. And there are lots of them. Hope you have a great day, and we'll talk soon.